Hello. It's Attorney Allie Booker. Hello and welcome to the Court of My Public Opinion. Let's adjust this real quick. Okay, without further ado, let us begin. Okay. And you guys already know you can write me. This is going to go on my YouTube page. It's going to be a little longer of an answer just so that people understand. I've put short ones on TikTok. Those are going to be like a minute to a minute and a half. More medium length, 2 minutes to 3 minutes, are going to be on Instagram. And here are my longer ones. Okay, and so YouTube, it's LegalQTee. Instagram, she_ya, that's YA_lawyer. And then TikTok is going to be LegalQTee as well, just like on here. Let's get it crack-a-lackin'. Why would CPS, the managing conservator of the child, be mad that my lawyer filed a custody modification? I have a positive relationship with my caseworker for my son's case, but when the attorney I hired filed a modification for custody, they completely changed and now treat me like an absolute dog, like crap. They even bully me. The lawyers say it's the mod, but why is that? Okay, guys. A lot of the times people find themselves in a position where they may be in litigation with CPS or the Department of DFPS, the Department of Family and Protective Services for their particular state. Okay, here in Texas is DFPS, Department of Family and Protective Services, and they have different subsidiaries underneath them. One of them, which is CPS. They also have APS, which is Adult Protective Services. This individual is talking about a Child Protective Services case that they filed against this particular individual in court. If CPS believes that they must remove a child and you either A, will not allow the child to be removed, or CPS believes there is an emergency situation that causes them to have to get custody very quickly on an emergency basis, those are some of the reasons, amongst others, why they may file a case against a parent or a guardian in court. Okay? And so this parent says that CPS was determined the conservator, and that this parent filed a modification in and through their lawyer. Now, I don't know exactly what stage of the litigation this child is in with CPS. Clearly, they should not be in an adversarial proceeding, meaning I don't think that CPS has filed a case against this particular parent, and that this parent has counterfiled a modification, unless there was an ongoing case. It's in the juvenile court, and it does, and there's, it has to be in the juvenile court because the juvenile cases can go for a long time. So I'm gonna say that's where it's at. And so this case has been going for a while, and so Texas has had conservatorship of this child for a while on a temporary basis. So this parent is now coming in to modify. So it's more than likely, and I cannot say because the parent did not say, but it's probably in the juvenile courts. There's two places, okay, that CPS can sue a parent. One, they can sue you in the juvenile court. You'll be going to the Juvenile Justice Center and dealing with that system. It's still underneath the Texas Family Code. Or they will sue you off in family court, the same divorce court and custody court that you go to for any other reason. Okay, so I'm going to assume that this is a juvenile case because those cases tend to go for a little bit longer. And this is a play that I just don't see being run in an adversarial CPS case that's in a family court. And I say that because really all CPS cases, they're supposed to be done after a year. But the state has to move to extend that if they need the case open for longer than a year. No matter where it is brought, CPS is run by humans. Although it is a department of the government, humans are fallible and they may make mistakes. And inevitably, there's something that this attorney believes that he or she has seen that will warrant the court switching conservatorship back to his client from CPS. So he's filed a modification, which is generally rarely used. Again, most of the time you are trying to defend yourself against these people. You're not attempting to file proactive motions such as a motion to modify. Most of the time you're trying to prove that, excuse me, that you're a fit parent, that you're passing drug tests, etc. And you're so wrapped up and involved with doing that, that emotion to modify is not something that you would generally use. It's not a vehicle that's available to you, and amongst other things. So I'll explain to you, and I'll say it like this. You have a CPS caseworker, okay? You also have their supervisors, etc. Okay? You have a CPS investigator, okay? The investigator and the CPS worker are two separate people. The first people that knock on your door or call your phone when there is a CPS case is going to be the investigator. The investigator runs an investigation to determine whether or not they believe there has been some sort of violation, and they will make their finding and go on from there. If it's something that warrants the child being taken out of the home after the violation is found or before, you go to court. And in this particular case, yes, anytime you're finding CPS, they will get a little bit tighter and restrictor on you. They will restrict access if they can. They will fight back at you. So yes, if your lawyer has filed a modification against them and you've kind of caught them with their pants down per se, they're not going to be very nice about it. Okay, and neither are their CPS caseworkers. One thing that I always tell people is to cover yourself. Anything that you send your CPS worker needs to also be sent to your lawyer. Okay, you don't just send stuff to the CPS worker or give things in hand to a CPS worker. They are human beings. They may misplace it, and if they don't have it and they don't have a record that it has been given to them, then they're going to say that you didn't turn it in. So you need to always make sure that your attorney is also given these things. That's one rule of thumb. Number two, it's a risky thing to do. I do it in most of my cases, but you have to establish your own relationship with the CPS worker. There are a lot of and sometimes I will not allow my clients to speak with CPS without me. But much of the time I will, because you have to build a rapport with the CPS worker to where the CPS worker can trust you. The words of that CPS worker can make or break you. The words of that CPS worker can make or break the case. And if a CPS worker doesn't believe that you need to be watched, he or she's going to tell their supervisor that, and he or she's going to tell the attorney for CPS, which is the county attorney, okay, in your area, that. And that may very well have a bearing on the county attorney and how they change the course of litigation. They may be upset with you and then all of a sudden be on your side, even the county attorney. And that namely is done mainly through the CPS worker. If I have a bad client, a client that I don't trust, one that I don't think that is going to follow the rules, that's more than likely one that I probably will not allow to talk to CPS, and it will drive up the price and cost of the case. But it seems as if this person is speaking with CPS on their own. So, sir, it's the nature of the game. When you go to expose and show somebody else's shortcomings and their faults, they're going to do the same to you. So that's exactly what's happening in this case. You guys have a fantastic day. If you have any questions, please feel free to call 713-292-2225 so that your question can be entered so that we can answer it here. You can also email booker@bookerlawfirm.com so that we can get your question on the show. Okay? Thank you, and you guys have a fantastic day.